about this controversy in Indiana about something called the Religious Freedom Restoration Act law. And oftentimes, the way that this gets portrayed is entirely spun, or is entirely shaped by the perspective of the people who are writing the headlines. So, for example, the other day I saw a headline that said that Governor Mike Pence had passed an anti-gay piece of legislation, or that he had signed an LGBT discrimination bill. So the overall impression that comes across sometimes is that the bill that was passed was specifically designed to permit and make legal or keep legal discrimination against LGBT members, people in Indiana. So as I was looking at it, at first I wasn't going to talk about it in class, and I just kind of let it pass. But then I thought, probably a bunch of you are going home this weekend for Easter, or you're going to at least take a break. And my guess is that somebody's going to ask you what you think about this. They'll tell them you're taking an American government class, and they'll say, "Oh, have you been talking about this whole thing in Indiana? Can you believe this?" And so I thought that in the interest of equipping you to have some knowledge base on which to work with regard to this issue, that I would take today and talk about it. So most of what I know about this has been developed. I've researched this over the last few days once I made the decision to look at it. I'm not an absolute expert in this area, but as you know already, we've talked about this in class already, that I do research a lot in the area of religion and politics. And so I have a general background on this, but I wasn't really familiar at all with Indiana's law or kind of how it fit in the broad scheme of things. So I developed this over the last couple of days to try to educate you so that you would have information about what this is about. So I have a not very imaginative title for this, that Indiana Religious Freedom Restoration Act controversy. So my goal in this, and as you know, I try to do this throughout the course, my goal is to help you understand what the conflict is, to help you understand what the legal and the historical background is, so that you then, and then at the end I'm going to give you resources that will give you both sides of the perspective, so that you can look at what they say, you can look at their arguments, you can look at how they're approaching the issue, and then you can make your own evaluation about that information. So my goal here is to help you understand the context so that you can discuss it with an informed background, and then we can and then you can look at the resources yourself, see what's online, and make your own choices, make your own decisions. So the way I've posed this is in terms of questions and answers, because I had a lot of questions too, and some of it was really basic, like what is the big deal? And then I got a little bit more sophisticated in terms of the way I presented this information. So a lot of this is presented really straightforward, in a really straightforward way as questions and answers. First of all is, what is the law that people are saying is so controversial in Indiana in the first place? So the question is, what is the RFRA in Indiana? And I'm going to keep using that shorthand for it, because after a while it gets really hard to keep saying without stumbling and stuttering Religious Freedom Restoration Act. I'm just going to refer to this as a RFRA Act. Okay? RFRA. A RFRA Act. Not RFRA, no. So what is the RFRA Act in Indiana? The RFRA Act in Indiana is a way of establishing in Indiana a certain standard for how religious freedom gets litigated in the state. So for example, if the state makes a law and somebody who's of a certain religious persuasion thinks that that law has infringed on their religious liberty, then how do they litigate that into the state court system? And so all around the country you've got states that have been passing these RFRA Acts. So this is essentially a law that sets up a 3-step test for how to litigate a challenge to the religious freedom law, to a law that impacts religious freedom in the state of Indiana. Remember that under the Constitution and the First Amendment, it says Congress may not pass a law to restrict the free exercise of religion. Right? So that's what the Constitution says. We know that applies to the federal government, and that was the intent back then. We've also learned, as we discussed in civil liberties and civil rights, that over time, the Bill of Rights, of which the First Amendment is one, came to be applied to the states through the process of selective incorporation. That is, right by right, liberty by liberty, case by case. All of these things in the first 10 amendments came to be applied to the states. So the first basic question is, this is saying that we're going to set up Indiana's right to set up a law about how to litigate cases in which somebody believes that their First Amendment protection of free exercise has been violated by a state law, or by a, it could be a city law, or it could be a county provision, or something like that. Laws that are set up by the civil governments in Indiana when people feel that their religious liberties have been infringed. As we talked about with religious liberty, you remember that we saw that the United States Supreme Court ruled a couple of years ago in the Hobby Lobby case. It confirmed a long history in the United States that the civil liberties that we read about in the first several amendments of the Constitution don't just apply to individuals like you and me, but they also apply to organizations that we own and run. So if I form a business, then the civil liberties I have as an individual also apply to the business. Okay, so we saw that. I even put up a quote from the Supreme Court that confirmed that this is a long-standing tradition and has been encoded in U.S. law for many, many years. Okay. So the next question is, how does this law in Indiana relate to other RFRAs? And I'll talk about other RFRAs in a moment. But how does the one in Indiana relate to this? Because Indiana is the one with controversy, although I'll point out that yesterday the governor of Arkansas also signed a RFRA in Arkansas. Okay, so this is not just in Indiana. The law in Indiana is similar to most other RFRAs, but it's also different in one case. So it's similar to other RFRAs in that they all basically set up the same three-step process for how to litigate and how judges should make decisions in these cases where people are arguing that government has infringed on their freedom of religion. Okay? What's different about Indiana's case is that Indiana then also includes a provision in there where if you are sued for discrimination, that you can use the state's RFRA as a defense mechanism. That is, in the process of putting together your legal defense for being sued, an Indiana resident can use Indiana's RFRA as a way of saying, I'm allowed to do this, and you're allowed to not allowed to do this, but I'm allowed to ask the judge to use these steps in order to adjudicate the case. So again, the RFRA sets up a three-step process, and it says that you can use this when you're being sued by the government or being challenged by the government, but it also says the individuals suing each other, that this law can come into play as well. Okay? Now, not all the states that have RFRAs have this individual component. And as it turns out, this individual component is the one that is generating the most controversy. So people who are opposed to this act, they're saying what this allows people to do in Indiana is to legally discriminate against same-sex couples, legally discriminate against the LGBT community, and do so because they say it's a religious belief. Okay? That's the argument that's being made. So the question is, does that stand up? Is that a real threat? And how can we evaluate whether that's a real problem that's out there? So the states in this map are the states in green are states that have already had passed their own state-level religious freedom restoration acts. And most of these, and all of these have been passed since 1997. And we'll talk about in a minute why it started in 1997. But all of the green states have RFRA laws that are essentially the same as Indiana's, except for that individual adjudication thing, that individual lawsuit thing. That's sometimes successful in getting passed in states, sometimes it's not. For example, in 2014, Arizona tried to amend its RFRA Act to add in the individual protection, the individual process for adjudication in lawsuits, and the state legislature failed to pass that. So that did not pass in New Mexico. But there are a handful of other states where this individual adjudication element is included in their state RFRA. In the yellow states are where there's not been a law passed by the legislature, but that the state Supreme Court has ruled that the same kinds of things that are protected by these other state RFRAs apply in those states. So for example, in North Carolina, they don't have a RFRA Act passed by their legislature, but in these religious liberty controversies, the state courts have said the principles of RFRA, this three-step process, this is the process we have to use in adjudicating these kinds of conflicts between governments and citizens. So this idea, for example, that in Indiana, that this is something that's new and unique and weird and abhorrent in Indiana, it's just simply not the case, because this has been going on for a long time, passing these kinds of laws. So all this kind of goes back and begs the question, why was the first RFRA passed? And so here's where we need a little bit of constitutional history. So remember, the language of the First Amendment is that Congress may make no law respecting the establishment of religion or prohibiting the free exercise thereof. Now, as we know, there is no absolute liberty. That is, it's not like Congress can never, ever pass a law restricting somebody's free exercise of religion. We know that that's not the case. It's not the case certainly in terms of freedom of speech. Congress passes laws all the time restricting freedom of speech. Congress passes laws all the time prohibiting or regulating freedom of assembly and the right to own guns and so forth. So the rights that are expressed in the Bill of Rights are not absolute. There have always been efforts by the government to try to regulate what people do, even in terms of speech and things like that are constitutionally protected. So the same thing applies here. So what happened is that up until 1990, there was this three-step process for when there was a conflict between the government and citizens that involved citizens' religious liberty. There was this three-step process that had been in place officially for about 30 years. And this is known as the Sherbert Test. And the Sherbert Test, which we'll look at here in just a second, has nothing to do with kind of fruit-flavored ice cream. The Sherbert Test actually has to do with setting up a series of steps for evaluating whether the government's justified in restricting somebody's religious liberty. So under the Sherbert Test, government restrictions fall under the idea of strict scrutiny. Remember from the language of the Civil Liberties and the Civil Rights chapter, we have this idea, this concept of strict scrutiny. And the basic idea here is that if the government is going to restrict your liberty, its justification really has to be looked at quite strictly. There really has to be a careful examination of the justification for restricting somebody's liberty. And in the legal language, the court's language, this is called strict scrutiny. And so there was this three-step process that was set up for establishing the process of strict scrutiny under the Sherbert decision. And it's a three-step process. The first question here is, does the claim against a person, so let's say, for example, an individual says, no, I have a religious reason for doing what I do, and the government, for some reason, is charging me with a crime for doing something that they have said is a crime, but I'm saying it's my religious liberty to do this. Okay, for Native Americans, it could be smoking peyote, hallucinogenic drug, when the government has these general drug laws. Or in the case of one woman who is actually in the Sherbert case, is that she was a Seventh-day Adventist, which is a small Christian sect. And the Seventh-day Adventists believe you can't you can't do any work whatsoever on Saturdays. And so there was an ordinance, she was fired from her job for not working on Saturday when it was a religious conviction. And then the question was, is the employer unfairly discriminating? Are they basically discriminating on the basis of religious belief? So then the question is, in these kinds of challenges, how do you decide who's right? So the first one is, does the claim involve a person's sincere religious belief? So it's got to be something that you can demonstrate that this is something that you really believe, that comes out of a clear teaching from your own religion, regardless of what the religion is. So what's interesting in a lot of these is that they don't really have anything to do with Christianity per se. The critics of the current RFRA law say that this is really about protecting the religious liberty of Christians. But most of the cases in which this this body of law developed weren't involving Christians. They were almost always involving small minority sects, such as Native American religions, small fringe sects of Christianity, Jewish citizens, Muslims, and so forth. So most of this body of law comes out of small minority sects that the majority would certainly want to try to shut down. So the first stage is the claim involved person's sincere religious belief. The second step is, if that's the case, does the government have a compelling state interest for introducing that burden on the person? Is there a compelling state interest? That is there a really good reason for the government to stop this person from doing these kinds of behaviors? And then if there's a really good compelling case, then the third step in this is the government using the least restrictive means for incorporating that? So that if the government's allowed to pursue a compelling interest and to restrict people's religious behavior, is the government actually using the least restrictive means, that is a process that does the least harm to somebody's religious liberty? Now when we think about the Hobby Lobby case, this is exactly the process they went through. So the Hobby Lobby case, the Supreme Court looked at, is this a sincere religious belief? And they decided, yes, this is a sincere religious belief on the part of the Green family. The second step is, does this appear to, does the state have a clear, compelling interest to make sure that women have access to abortion-inducing drugs? And the case was argued, yes, that seems like a plausible, compelling reason for the state to introduce these laws. And then the third question is the Affordable Care Act requirement of companies to provide these abortion-inducing drugs, is that the least restrictive way that women could have access to that? And the court said no. So in the case of the Hobby Lobby case, it said sincere religious belief, there's a clear, compelling policy reason for the government to encourage this availability, but that the government overstepped in terms of forcing Christians who own companies to provide these to their employees, violating their religious conscience. So this is the exact same process that was used for Hobby Lobby. So this was the main law, the way that all of these cases were decided from about the 1950s up until 1990. This is called the Sherbert Test. Essentially, the Sherbert Test puts the burden of proof on the government for burdening somebody's free exercise of religion. And this is consistent with the way the First Amendment is written, right? Congress shall make no law prohibiting the free exercise thereof. Okay, so the question is, who has the burden of proof? Do you have to prove that you have the right to exercise your religion, or does the government have to prove the reason that they should restrict your natural free exercise right? Okay, that's the question. So in this process, you have these step-by-step actions and decision points for the courts in terms of evaluating whether the government is justified or whether the individual needs the protection. And you have to understand the overall mindset here is you have an inherent right to free exercise of your religion unless the government has a really strong reason for restricting your free exercise of your religion. Remember, you have an inherent fundamental right to your freedom of religion, and the government has to show why it's okay for them to provide an exception to your exercise in this way. So the process goes this way. Is this a matter of sincere belief? Do you have something in your religious belief system that is very clear in terms of the thing that you're talking about being violated? If there isn't a clear case, then the individual loses. So it's got to be a clear case, which means you have to be pretty well versed in terms of your own religious belief. You just can't say, well, I kind of think that Jews ought to act this way, and I'm Jewish, and so you kind of have to, I kind of think this way. No, it's got to be really clear. You got to be able to connect the dots and say, this is what I believe. This is why it comes directly out of my religious belief system, and then I can say this is sincere. It's harder for people who don't go to church to kind of claim this kind of thing. So if you say, I kind of grew up Christian-y, but I haven't been to church in 20 years, but now I want to discriminate based on my faith, the court's going to look at that and they're going to be pretty skeptical that it's a sincere religious belief on your part. Okay, so it's got to be sincere. If it is sincere, then the case goes to the next step. The next step is, does the government have a compelling reason to do the thing that it's doing, to make the requirement of you that it's making? If the government doesn't have a very clear, compelling reason, then the case is over. That case gets decided in favor of the individual. Okay? But if there is a clear and compelling reason for the government to be pursuing this policy goal in this way, then you go to the next step. When the government is doing this thing that puts a burden on people's religious exercise, are they using the least restrictive means possible? Or are they overreaching in terms of kind of, instead of trying to take care of something with a scalpel, they're trying to take care of it with a machete? You know, in terms of how they're burdening somebody. So is there a reasonable alternative that could be pursued that will still accomplish the goal the government's trying to accomplish, but without forcing people to violate their religious beliefs? So if there is no other reasonable alternative, then the individual will lose. If there is a reasonable alternative, then the government should have chosen that reasonable alternative instead of forcing people to violate their religious conscience. This is what RFRA does. It sets up this reasoning as the process by which courts adjudicate conflicts between governments and individuals. The language of Indiana's RFRA Act does this. The language of Arkansas's RFRA Act does this. All 20 states that have RFRA Acts, they are putting this into law. So that judges can't just kind of make it up as they go. Now, you can argue about whether this is an appropriate process for courts to follow. And we've been arguing about this for thousands of years, about how to best manage the relationship between individual exercise of their religious beliefs and what's in the public good. This is a matter of political debate. It's not going to end here, but this is what the RFRA laws set up. Now, this was the Supreme Court's decision about how you approach these kinds of questions until 1990. It puts the burden of proof on the government to demonstrate why they're justified in restricting people's religious beliefs, their exercise of their religious beliefs. There was a Supreme Court case made in 1990 that essentially says, yeah, we're going to change the set of rules. We're not going to do it that way. And instead it puts the burden of proof on individuals to demonstrate why they shouldn't be restricted. Do you hear the difference? In one case, the burden of proof is on the government to show why it's justified restricting individuals. In the other case, the question is getting the burden of proof on individuals to show why they shouldn't be restricted. So the pre-1990 decisions under the Sherbert Test for religious freedom is it puts the burden of proof on the government. Under this new rule called the Smith Rule, it set up a more of a vague kind of justification for courts that made it much harder for people to claim religious liberty, make religious liberty claims against the government. So what happened is that most people were really angry about this and frustrated about it. Okay? So you had civil liberties groups like the American Civil Liberties Union and a huge number of religious groups get together and say, we need to go back to this earlier standard because under the new standard, under the Smith standard, it's going to be hard for us to defend our religious liberty. So we're going to pass something called the Religious Freedom Restoration Act. The Religious Freedom Restoration Act was passed by Congress and put into law that the courts have to use the Sherbert Test steps to judge these cases, rather than the case that the way that they had used in 1990. So you had this case in 1990 that changed the standard for deciding the cases. And in 1992, you had this law go through Congress and President Clinton signed it into law in 1993. So we have a federal Religious Freedom Restoration Act. It's a federal law that instructs judges, federal judges, how to make these decisions. That's what the RFRA does at the national level. Now what's extraordinary about this in 1992-1993 is that you had huge players on the Democratic and Republican side both sponsoring this bill. Ted Kennedy, Democratic Senator from Massachusetts, he was a key sponsor of this bill in the Senate. Charles Schumer, who is at the time was a representative and now is probably going to be the next majority leader for the Democratic Party in the Senate. He was the co-sponsor in the House. Bill Clinton signed this bill into law. Nearly every Democrat voted for the federal RFRA Act in 1993, including Joe Biden and Nancy Pelosi. Okay? So this bill is not controversial. It was passed nearly unanimously, Democratic and Republican support. Bill Clinton said when he signed this into law, what this law basically says is the government should be held to a very high level of proof before it interferes with someone's free exercise of religion. This judgment is shared by the people of the United States as well by the Congress. We believe strongly that we can never be too vigilant in this work. At the time, Vice President Gore said, the fact is that the Religious Freedom Restoration Act is something that all Americans can support. The consensus in 1993 is that this was a clear extension of protection of individual liberties from unwarranted intrusion by the federal government. Uncontroversial. Democrats, Republicans, liberals, conservative, civil libertarians, economic, very clear, strong passage throughout. So what's the problem? Why do states have to pass their own RFRAs? If it's in the Constitution, First Amendment, you've got the Religious Freedom Restoration Act passed at the federal level. As you already know, that just because something is passed for the federal government doesn't automatically apply to the states. And in 1997, the Supreme Court ruled the Religious Freedom Restoration Act passed in 1993 does not apply to the states. It only applies to the federal government. This is not a new story. We've seen this throughout our history. Selective incorporation. It's got to be done on a liberty by liberty, right by right, case by case basis. So this is perfectly consistent. So, states, since that time, have been passing their own state religious freedom restoration acts. Beginning in 1997, people have been going into the state legislatures have been passing these. And what's interesting is that in Illinois, when that was the bill in Illinois, Barack Obama voted for it. Now, I actually have not heard what he has said about the Indiana law. I haven't heard, so I don't know one way or the other. But to me, it's interesting and important that in the process of passing these bills at the federal and the state levels, very prominent Democrats supported this. This is not a Republican-Democrat thing. And this was very across the board in terms of their support. So the big question is, how have the RFRAs been used? Because the fear among people who are opposed to the RFRA is that it will be used as a basis for justifying discrimination on the basis of sexual orientation. Now, if your state has a law prohibiting discrimination on the basis of sexual orientation, then you've got these two laws in conflict, prohibiting discrimination on sexual orientation and this RFRA Act. That's a legal conflict there. Because what if somebody discriminates claiming a religious belief? So that's a legitimate concern that they could use that as a means of justifying their discrimination. So what kinds of cases have actually been used? So there are a bunch of cases around the country where this has been used as a defense. So one example was in California. There were a bunch of churches that felt that zoning regulations by the state unfairly burdened them. They sued it, and using this process, the courts ruled that it failed to meet that first test. Remember the first test? Does this objection come from a sincerely held religious belief? Okay, the churches had to make the case. Yes, the location of our churches extends out of a sincerely held religious belief, and the court said, no. The churches lost. They didn't even get to the next step in terms of the compelling government interest. There was an employment discrimination case a few years ago in which a Lutheran church-related school fired an employee because she wouldn't sign on to the beliefs of the church in order to be an employee there. And so she sued them on the basis of employment discrimination and religious discrimination. And in this case, the courts decided that the church school itself was, because its belief came out of a legitimate set of religious beliefs, that you got to be a part of their sect in order to teach their kids, they said the church school wins. Okay, so you met those verdicts. There are prisoners from minority sect religions, such as Islam and so forth, that sued the state governments, saying that their religious freedom the right to exercise their religious freedom in prison was being infringed upon. They weren't allowed to have the kind of meals that their religion dictated. Even they weren't allowed to grow the beards. Just a couple months ago, the courts are ruling a case on whether Muslims in prison can be allowed to grow a beard or not, because there are regulations for growing beards in prison. So the question is this an unfair burden on Muslim men to prohibit them from growing beards? Is there a compelling state interest? I don't think that decision's been made. That's the kind of thing. In those cases, the prisoners won their cases against the states. Down in Florida last year, this was in the news quite a bit actually, there was a man who was feeding the homeless. He's got a ministry, and he's a Christian man, and he goes into the areas of, I think he was Fort Lauderdale. Going to Fort Lauderdale, and he's feeding the homeless people in Fort Lauderdale. But the Fort Lauderdale government said, no, we have a zoning restriction. We're going to set up these no social service zones in our city where social services cannot be offered, and these are designated according to where we have the most tourists. Basically, they don't want poor homeless people going to where the tourists are, and so we're going to make that harder for them by keeping people who want to minister and care for the homeless. We're going to keep them from offering services there. Is this guy's belief that he needs to be giving food to the hungry and taking care of the homeless, is that a sincerely held religious belief? He said yes. Does the government have a compelling interest to restrict where people can do certain stuff? Sometimes. Are they using the least restrictive means to keep social services from happening in these areas? They ruled no. The government had overreached in terms of prohibiting that. So in this case, the city lost. And the guy wanting to do the ministry of the social services, he won. Okay? So these are the kinds of cases that we're talking about. So now the big question is, what about this individual litigation? That's government versus individual. That's actually a little bit less, that's not really controversial. People aren't really objecting to this. Of course, governments are always trying to tell people what they can and can't do. So you have that kind of conflict. But what about this individual litigation provision within the Indiana law that basically says, if you want to run a business and discriminate against a same-sex marriage couple, can you claim the state's RFRA Act as a defense in doing so? Well, why would this be put in here? Part of the reason it's being put in there is because all over the country, you have these individual cases where Christians, primarily, are being sued by same-sex couples who want to get married, but who also want this particular service done by this particular company. So in one case, there's a florist who said, I can't in good conscience, according to my religious belief, I can't provide the flowers for your same-sex wedding, violates my religious belief. In another case, you've got photographers who say, I can't photograph your same-sex wedding because it violates my religious belief. In another case, a couple who owned a hall that they rent out said, I can't rent my hall out to you because of a sincerely held religious belief. I can't rent out to you because it's a same-sex couple that violates my sincerely held religious belief. I can't bake a cake for you. I can't print t-shirts for a gay pride parade. I can't do cards and things like that. So all over the country, people are being sued for not getting their business involved with these kinds of, primarily same-sex marriages, but it's also a few other kinds of things like gay pride marches. So they are in fact being sued, and so the solution to this is to provide a metric, some kind of a method for those people to have this RFRA defense and the process of judges adjudicating the lawsuits. So what's interesting about this is that the only times that these RFRA laws have actually been used as a defense, the court has ruled that the state's interest in prohibiting discrimination is a clear and compelling interest. And that the anti-discrimination laws are not an inappropriate way of restricting people's behavior. So in the cases where the plaintiffs have tried to use state RFRA laws to justify their discrimination, there is not a single case in which they've won. The state has the people suing the company have always been the one who have lost. So I was trying to communicate, I wanted to get a clear sense of this. And I was communicating with a constitutional lawyer. I said, because I don't know the law in this. So I contacted a constitutional lawyer. This is what he put in his Facebook message to me this morning. He said, no Christian has successfully used the RFRA to deny even wedding services. Those same arguments were raised in the New Mexico photographer's case and lost. There is no reported decision in any state or federal case where a RFRA or strict scrutiny has exempted any believer from application of discrimination laws. Because the courts are finding that anti-discrimination laws are a clear and compelling state interest, and that usually the process by which you resolve those is not overly burdensome on people of faith. So there's no case in which this is actually done in the favor of the person doing the discriminating. And it's always been decided in favor of the person who's being discriminated against. Okay? And he sent me to a law school article. Here's the URL. You can read it yourself. Go online, you can read it yourself. It's written by a law professor over at Wayne State University that in 2010 reviewed, I think there were 16 state RFRAs at the time, and he came to the exact same conclusion that the constitutional lawyer did. That this is extremely rare, and when it happens, it has never worked in the favor of the person claiming the right to discriminate.
Okay, now
Is that?
now it makes sense.
Okay. So, if you're interested in reading about this, write down this URL and you can go find it yourself. I want you to go look it up on your own. Don't just go off of the headlines that you read in the that you see on MSNBC or CNN or The Daily Show or whatever. No matter what the jokes are that Jon Stewart's going to tell about this, don't make that the primary source of your information on this. So here are groups that are in favor of the RFRA Acts.
Can you go back?
You go on their website. What's that?
Can you go back to that link?
Yeah.
Can you put that back up, please?
Yep. This link?
Yeah.
Yep. So my overall point that I'm trying to make here is what's the history of these RFRA Acts at the state level? What do the laws actually do? They set up a system for how judges decide the cases. They are not laws that allow people to discriminate. And even in cases where individuals are allowed to use the RFRA bill, the RFRA law, to justify their discrimination, there have been no cases in which that process has produced a victory for the discriminator. So I'm trying to be as even-handed in portraying the risks, portraying the way both sides are arguing about this, and what are the real challenges in terms of the social conflicts. Okay, so now here are the resources. Don't take my word for it. Even though I'm trying to be as even-handed as I can, decide for yourself. Read up on this, because somebody's going to want to know what you think because you're taking this super American government class. So if you're interested on the pro side, people who are saying we have to pass these RFRA Acts, everybody's overreacting, those are two groups that have a boatload of information on their websites. If you want the other side, the people who are saying this is a real concern for us in terms of violating the civil rights, the civil liberties of LGBT community, that it's a real risk, those are two organizations that have a boatload of information about that side of the argument. So don't just go off a knee-jerk headline on either side. I'm telling you, I did not know. I had to go look this stuff up for myself over these last few days. So I'm educating you very briefly, very shortly after I educated myself. And by the way, it only took me about 2 hours to pull all this stuff together. Okay? So if you're interested in this topic, then this might be worth your time to put in the effort so that you can educate yourself. So that you can speak intelligently about it instead of just people yelling at each other on TV. Questions? We've got about 5 minutes left for questions. love it when I do a great job. All right, let's call it a day. If you're headed